Building on our understanding of title insurance and how ownership is secured through clear title, we now shift focus to one of the most common lending instruments in Arizona real estate, the deed of trust. This document is central to how real estate financing functions in the state, serving as the legal mechanism that secures repayment of a loan through an interest in property. Unlike some states that use mortgages, Arizona is a deed of trust state, meaning that real property transactions typically involve three parties instead of two. These three parties, the truster, trustee, and beneficiary, each play a distinct and legally defined role governed by Arizona law. Under ARS, paragraph 33-801 through paragraph 33-821, the Deed of Trust Act provides the statutory framework that defines how a deed of trust is created, recorded, and enforced. Understanding the roles of the involved parties is essential for all real estate professionals because their actions, rights, and obligations directly affect the validity of the transaction, the enforcement of the loan, and ultimately, ownership rights. The truster, the borrower and property owner, the truster, also known as the borrower, is the individual or entity who takes out the loan and pledges their property as security for repayment. In this arrangement, the truster retains equitable title, meaning they have the right to occupy, use, and enjoy the property while still owing money to the lender. The truster's legal responsibility includes making regular payments, maintaining the property, and complying with the loan terms outlined in the promissory note and deed of trust. For example, if a buyer in Phoenix purchases a home using financing, they sign both a promissory note, the promise to repay the loan, and a deed of trust, the security instrument that ties the property to the obligation. The truster grants temporary title rights to the trustee as collateral until the debt is satisfied. Once the loan is repaid, the trustee reconveys the title back to the truster, restoring full ownership rights. Under Arizona law, if the truster defaults on the loan, they may lose the property through a trustee's sale, a non-judicial foreclosure process authorized under ARS, paragraph 33-807. This process allows for quicker resolution than judicial foreclosure and avoids the involvement of courts unless challenged. The beneficiary, the lender or creditor. The beneficiary is the party that extends the financing, typically a bank, credit union, or mortgage company. The beneficiary holds the promissory note, which represents the debt and has the legal right to enforce the terms of repayment. In essence, the beneficiary is the one who benefits from the deed of trust because it serves as their protection in case of borrower default. For instance, if a homeowner fails to make mortgage payments, the beneficiary can direct the trustee to initiate foreclosure proceedings. This right is secured under Arizona's Deed of Trust Act and allows the beneficiary to recover the balance owed by selling the property through a trustee's sale. The beneficiary's interest is therefore not in the property itself, but in the repayment of the loan, which the property secures. Arizona law requires that once the beneficiary receives full payment, they instruct the trustee to execute a deed of release and reconveyance, removing the lien and restoring clear title to the borrower. Failure to do so in a timely manner can result in statutory penalties under ARS, paragraph 33-707. The trustee, the neutral third party. The trustee serves as an independent and neutral third party who holds legal title to the property in trust for the duration of the loan. The trustee's role is not to favor either side, but to ensure that the terms of the deed of trust are followed as written. The trustee's duties include holding the title until the loan is paid off, reconveying title to the borrower upon full repayment, initiating foreclosure proceedings if directed by the beneficiary in the event of default. In practice, the trustee is often a title company, attorney, or financial institution authorized to conduct trustee sales under Arizona law. Because the trustee must remain neutral, they cannot act in a way that benefits one party at the expense of the other. For example, during a trustee's sale, The trustee must strictly follow the procedural requirements outlined in ARS. Paragraph 33-808, including providing notice of sale, posting publication, and conducting a fair auction. Any deviation can invalidate the sale or result in liability. Interrelationship between the parties. The deed of trust creates a three-party relationship where each has a specific legal role. The trustor conveys title to the trustee as security for the debt owed to the beneficiary. The beneficiary relies on the trustee to ensure that their security interest is protected, while the trustor retains possession and use of the property as long as they comply with the loan terms. This relationship exemplifies the dual nature of property ownership in Arizona: equitable title held by the borrower and legal title held by the trustee. When the loan is fully paid, these interests merge, restoring full ownership to the borrower. For example, consider a homeowner in Gilbert who finances a property through a local bank. The deed of trust names the homeowner as trustor, the bank as beneficiary, and a title company as trustee. The homeowner enjoys full use of the home, but acknowledges that the trustee holds legal title until repayment. If payments are completed, the trustee issues a reconveyance deed. If the borrower defaults, the beneficiary instructs the trustee to proceed with foreclosure according to statute, judicial precedent, and legal framework. Arizona courts have long upheld the validity and enforceability of the deed of trust structure. In Patton v. First Federal Savings and Loan Association of Phoenix, 1978, the Arizona Supreme Court recognized the deed of trust as a distinct legal instrument, separate from a mortgage, and upheld the non-judicial foreclosure process as consistent with due process when properly executed. Similarly, in Recrone, 2002, reaffirmed that a deed of trust conveys both a security interest and limited legal title to the trustee, subject to the borrower's equitable right of redemption before the sale. These cases illustrate that while a borrower retains substantial rights, the beneficiary and trustee also hold legally enforceable powers under Arizona's statutes. Together, they create a balanced system that protects lenders' financial interests while providing borrowers with transparency, notice, and opportunity to cure defaults before losing ownership. Discussion: who holds equitable title in a deed of trust arrangement? Answer: the trustor, borrower, holds equitable title because they have the right to occupy and use the property while making payments. What is the primary role of the trustee in a deed of trust? Answer: the trustee acts as a neutral third party, holding legal title to the property and ensuring that the terms of the deed of trust are carried out, including reconveying title or conducting foreclosure when appropriate. When does the beneficiary lose their interest in the property? Answer: the beneficiary's interest ends when the loan is paid in full, and the trustee records a deed of release and reconveyance. Review summary. The deed of trust is the foundation of most Arizona real estate financing, creating a three-party arrangement among the trustor, trustee, and beneficiary. The trustor is the borrower who holds equitable title and repays the loan. The beneficiary is the lender who holds the promissory note and security interest. And the trustee is the neutral party who holds legal title and ensures compliance with statutory procedures. Under ARS, paragraph 33-801 through paragraph 33-821, this structure allows for efficient, non-judicial foreclosure while maintaining fairness and transparency for all parties. Arizona case law, including Patton v. First Federal Savings and Loan Association of Phoenix and in Recrone, affirms the legality and procedural safeguards of this system. Together, these roles ensure that property rights are protected, loans are enforceable, and the transfer of ownership or foreclosure occurs in accordance with law.